Well, hello everyone, and thank you for joining me. My name is Lior Samfiru, and I'm glad to be here with you. I'm the employment lawyer, that's what they call me, and I'm here on this live session to do just that, to talk about employment law, to tell you what you need to know, but most importantly, to answer your questions. This is a live session, folks. I want your questions on this session, and I want to have the opportunity to help all of you. If you're just joining us for the first time, you want to know who I am, let me tell you a bit about me. Again, I'm Lior Samfiru, the employment lawyer. I am one of the founding partners of Samfiru to Market LLP. You can find us across Ontario, BC, and Alberta, and we're the biggest employment law firm in this country. And I spend a lot of my time, as you may know, on TV, on radio, right here online, answering questions, talking to you about legal rights, making sure that you know that there is help, there is things that you can do, there are rights that you have when it comes to workplace rights. And the best way right now to start the conversation is just to ask a question, to tell me what your issue is, and I can give you information. I can tell you what it means. I can tell you what the law says. I can provide that support for you. So if you're dealing with a wrongful dismissal, you were let go, you don't think it's right, you haven't been paid what you're owed, you're staring at these termination letters, trying to make sense out of it. I've done this for 22 years. I've seen it all. Ask me the question. Ask me what to do, and I'll tell you. If you're being mistreated by a bad boss or a coworker, what to do, how to respond, what your rights are, ask the question. If your job is being changed, your hours, your days of work, your responsibilities, your work location, business is sold, ask the question. I'll tell you what you need to know. And, there's so many more things you can ask about when it comes to your employment law rights. We all have the right to know what our rights are. We all have jobs, right? But we don't always know what our rights are. On this session, you can find out those rights. So ask a question and make sure that you get the information that you need. Let me give you some other contact information before I start answering questions. If at any point you want to connect with myself and my team, if you're in Ontario and BC or in Alberta, you want to connect with my team, so easy to do. You just go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. It's a place you go to get answers to your questions and, of course, to connect with us and get us to roll up our sleeves so we can get to work and help you resolve your workplace issues. So, again, employmentlawyer.ca, phone number is there. Email address is there. It's all there right for you. But right now, hey, I'm live. I'm going to start answering your questions right now, but I want yours. You have so much time right now. So ask a question. Don't hesitate. Don't walk away from the session without having your question answered. So ask it. All right. Again, I'm Lior Samfiru, the employment lawyer. Let's get questions answered. Okay, let's see. First question today comes to us from Facebook from KC. I've worked for a company for 7 years. They restructured and fired 75% of my team, leaving only me with no replacements. I've been dealing with mental health issues and the previous cancer diagnosis. And now with this, I am stressed beyond belief. I'm scared that if I disclose my mental health issues to my employer, they will fire me, offer me severance if I disclose this, or is that a protected ground? So the thing is about disclosing your medical condition, it's not necessarily enough that you tell them, hey, I have a condition. And by the way, you should never tell your employer the nature of your condition. Is it really your employer's business if you're suffering from a physical ailment or from mental health issues? No. If you need to be off work or if you need your employer to support you, all you need is a doctor's note saying, I have an issue or this person has an issue and they need some support. That's it. You don't need to tell them what it is. And once you have that doctor's note, they're not allowed to fire you. They're not allowed to punish you. And they have to accommodate you. That accommodation may be to give you whatever time off you need. They may be to give you modified duties, modified hours, additional support. They have to do that. It's not something that they do if they're nice. They're legally obligated and required to do that. If they try to do anything other than that, if they let you go, that's a human rights violation, okay? Not to mention wrongful dismissal. If they do anything other than support you, illegal, and you call me and I'll deal with it. So get a doctor's note. You don't have to disclose the nature of your condition. If your employer asks, well, what is the medical condition? You don't have to tell them, and you shouldn't tell them. It's none of their business. What they need to know is that there is a medical condition that impacts your ability to work. That's it. The nature of that condition, off bounds, none of their business. So KC, any issues here, any problems, anything your employer does to you other than support you, you call me right away. To connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca, place to go, very easy to connect. So let's make that happen. That was the first question. You see how easy it is. Casey had a question, a very obviously difficult issue for her, a stressful issue. I get it, but she has an answer now. She knows what to do. She knows what her rights are. Same with you right now. If you're watching, you can find out by your situation if what your employer is doing is legal or illegal. If there's options for you, what you should be doing and maybe what you should not be doing. So ask the question right now. Again, if you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And of course, I'm here live with you right now answering your questions. So I can't answer them unless you ask them. So ask them. All right, let's see. Next question today comes to us on YouTube from Ahmed. How do you figure out what common law entitlements are? Is there a formula? So what Ahmed means in terms of common law entitlements, it means the full severance that someone is owed if they lose their job. So sometimes we call that common law severance. Really all that means is your entire severance amount that you're owed. So people sometimes believe that, oh, I get a week per year if I lose my job, or 2 weeks per year, or any other formula. Wrong, false, not true. It's significantly more than that. The factors that go into assessing how much you're owed are your age, your position, and the length of your employment. There's a few other factors, but those are the main ones. The longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. So there's not a direct line where if you work this much, you get that amount of time. So how do you find out? Well, there's a couple of ways to find out what you're owed. First thing, you call me, you email me, and I'll tell you. But you don't even need to do that. If you want to find out now, tomorrow, whenever you want, how much severance you're owed, what your common law severance is, very easy to do. Grab your smartphone, tablet, desktop, laptop, and go to pocketemploymentlawyer.ca. You see that address right now on the screen, pocketemploymentlawyer.ca. When you're there, you just click on the severance calculator. Ta-da, you're done. The severance calculator is a tool that we created many years ago. Over 2.5 million people across Canada have used it. And when you go there, you can find out in seconds how much severance you are owed. You answer a few questions, and it's going to tell you, hey, you're owed 16 months severance, 20 months severance, 7 months severance. It's completely easy to use. By the way, completely free, completely anonymous. Can't put a credit card in if you want to. You don't have to put in your name, the company's name. It's no strings attached. If you want to, you can also contact me from the severance calculator, only if you want to. So pocketemploymentlawyer.ca, make it the very first place you go to if you lose your job. So many times, 90% of the time, when someone loses their job, they are offered less, a lot less than what they're actually owed. And most of them accept it because they don't know better. Well, you now know better. So don't let it happen to you. If you lose your job, call me, or even easier, go to pocketemploymentlawyer.ca, click on the severance calculator. All right. Thank you, Ahmed, for that question. Fantastic. I appreciate it. I love those questions. More questions are coming in. Bring them in. Bring them in. I promise I'll get to all of them. Let's continue answering questions. By the way, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm going to continue answering questions. Stu has our next question. I was let go from my position while on maternity leave. My employer is not providing me with a severance offer and is no longer responding to emails. What can I do? Well, there's really only one answer here is call me. It's as simple as that, right? To connect with me and my team, pocketemploymentlawyer. Well, you can go there as well, or you can just go to employmentlawyer.ca. Again, employmentlawyer.ca. Because number one, you're not allowed to be let go when you're on maternity leave. You are owed severance. Your employer can't ignore you. So what you've described there, Stu, is human rights violation, employment standards violation, wrongful dismissal, bad faith. You get it. Illegal completely. It's so illegal, I don't even need to talk about it anymore. Ridiculous. So, but the real answer is, what do? You call me. You see how fast I resolve it, and you see how the company cannot ignore me. All right. So just connect with me, employmentlawyer.ca. Phone number is there. Email address is there. Let's get this done. All right. Thank you for that, Stu. Waiting to connect with you. All right. Let's see. More questions coming in. Let's get them answered. You as well at home, you have time. Ask your question. Brian, how's our next question? If a company lays you off, can they bring you back with a salary reduction? So let's start with the fact that a company does not have a right to put you on a temporary layoff. What I mean by that is if they put you on a temporary layoff, in most cases, not in every case, but in most cases, you may have the ability to consider that a termination and require them to pay you severance. Call that constructive dismissal. So for most people, just by putting you on layoff, doesn't matter what they were planning on doing. No, they don't have a right to do that, meaning you can consider that a termination and get severance. But let's say you don't do that. Let's say you're okay with the layoff. You're going to wait to be called back, and you'll get called back to work, but they are going to offer you less money. Well, no, the same concept of constructive dismissal. An employer doesn't have the right to make significant changes to terms of employment. So if your pay reduction is, let's say, north of 10%, that could be a constructive dismissal. If it's a very minor change, yeah, they probably could get away with it. But if it's a significant change, north of 10, 15%, let's say, or more, then that's a constructive dismissal, meaning you can't physically stop them from doing that, but you can say, no, I'm not okay with that. I'm going to treat that as a termination and get my full severance. If that's what you want to do, call me and we'll make that happen. Again, to connect with me, employmentlawyer.ca. Remember, with a temporary layoff, you have the choice in most cases to wait at home and see what happens, or to say, no, I'm going to move on to a different job and I'm going to consider the temporary layoff a termination and get my full severance. So those are the options, and that's what you can do. Again, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. All right, more questions have come in. I'm going to answer them. I'm not going to ask them. I'm going to answer them. But you have time, still plenty of time. We're not even a third of the way done through this session, so you have time to think about your question, type it in, hit enter, and let me read it and answer it. So let's make sure we do that. I'm Lior Samfiru, the employment lawyer. Let's get those answered. All right, Courtney, how's our next question? Courtney says, my employer breached my confidentiality. I came back from my medical leave of absence, and everybody on the floor knew why I was off. I told the union, they said that I don't need a lawyer. I don't know what to do. Well, in a situation like that, in most cases, only the union is allowed to help you. If you're a unionized employee, the union is allowed to help you, and they could pursue a grievance. Whether they do it or not really is up to the union. You can't really take legal action against your employer arising from your employment if you're a unionized employee. So if your union is telling you nothing you can do, there's not going to be much that you can do. It'd be very different if you're a non-union employee. Yes, you could take legal action here. We can decide whether that makes sense or not, but you don't have that option. You have to go with what the union says. And I want to also make it clear that everything you hear me talk on this session, or really if you hear me talk on TV or radio, all of that only applies to non-union employees. It does not apply to unionized employees. A unionized employee is bound by the collective agreement, and only the union can advise them or help them pursue rights. All right. So that's the answer there, Courtney. All right. Continuing to answer questions. Sam Liu, kind of similar to my name. I'm Samfiru. You're Sam Liu. Sam Liu, currently off on short-term disability, and the employer has said they've replaced my position and there's nowhere for me to return to. What sorts of rights do I have in this situation? I'm an 11-year employee. So the real question is, did they terminate your employment, or did they just hire someone to replace you? Because if you're on disability right now, you may still be on disability for a while. And the real question is there a job for you when you're ready to come back to work? Today, there may not be a job for you, but there could be one tomorrow or next month or 6 months from now when you're ready to come back to work. But if they've already said, no, you're gone, you're out of here, that's a problem, because number one, they shouldn't be doing that. They cannot and should not let you go while you're on a disability leave, okay? So that could be a human rights violation. And of course, you are owed severance. Now, you tell me you've been there for 11 years. I don't know exactly the job that you were doing or your age, but you could easily be owed a year's pay, 12 months pay. It could even be more than that, depending on your age and position. So that's the severance that you're owed. But again, potentially the termination itself may be illegal. If they just said, hey, heads up, we hired a replacement, you haven't yet been terminated. You may be terminated when you're ready to come back to work if there's no job for you. But if they've already said you're gone, there's no job, we're letting you go, then you're owed severance right now, potentially human rights damages as well. So Sam Lou, hopefully that makes sense. What I want you to do, of course, is I want you to connect with me off social media, off air. And you do that by going to employmentlawyer.ca. You see that on the screen, employmentlawyer.ca, because my phone number is there, my email address is there, all the contact information you need is there to connect with me so we can actually help you get that compensation that you're owed, okay? So Sam Lou, now you know better, employmentlawyer.ca. Looking forward to connecting with you as soon as possible to make sure that you're not taken advantage of. Thank you for that question. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm here live answering your questions, your burning questions when it comes to employment law. And I'm going to do that right now. Let's see. Next question is from Krista. Ask yours too, by the way. I have been on long-term disability for almost a year due to harassment and bullying at work. I was due to go back to work and they terminated me. Wow. I have worked with them for 15 years. What do I do with this? Well, let me answer the real question is, what do you do with this? You should know by now. You call me, right? That's what you do. You connect with me through employmentlawyer.ca, and we'll make sure you get what you're owed. Number one is if you're coming back to work, if they terminated you, that could be a human rights violation. Why did they terminate you? Is there no job available for you? Could they have found a job for you? Is it because you raised the issue of harassment in the past? All that could be illegal. And of course, beyond that, even if we forget about that, not that we would, it's a question of severance. You've been there for 15 years. I don't know exactly your age or your job, but you're probably going to be owed, 12 to 16 months of severance, months, not weeks. So we have to make sure you get that as well. So potentially the termination is illegal. Even if it is legal, you're owed could be as much as 16 months severance, could even be more than that, depending on those factors. So Krista, you know what to do. I told you, right? You connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. My phone number is there. My whole team's numbers are there. Email addresses are there. You can fill out a form and we'll call you. It's all there. So you know what to do. Call us. Don't let them get away with it. We need to make sure you get what you're owed. So Krista, I want to hear from you hopefully later today, employmentlawyer.ca. Fantastic. Lots of questions today. I will get to all of them. Next question from Sarah. If your employment contract says that if you are terminated without cause, that you'll be paid the minimum as stated in the Employment Standards Act, are you still entitled to more severance as shown in the in the severance calculator? So the answer is, in the vast majority of cases, even if you sign an employment agreement that tries to limit your entitlements, you may still be owed your full severance. There's various reasons why those terms may end up being unenforceable. So even though your employer tried to limit your entitlements in the employment agreement, there may be ways around it. But of course, every case is different. I would have to read the employment agreement to be able to advise you on your specific situation. But in my experience, probably in about 80% of cases, there are reasons and ways around that agreement so that you can still get your full severance. But there is an important lesson here. If you sign an employment agreement, you just got a job offer, you're excited, take a look at that agreement. Does it try to limit your future severance? Happy to look at it for you, because if it does, that may be something you need to negotiate. You don't want to agree to something that down the road can cost you tens of thousands of dollars. That's how much it could cost you. So let's do that correctly. Now you know better. So thank you for that question, Sarah. And you know how to reach me now or in the future, employmentlawyer.ca. All right, let's see. Top Programmer has our next question. Retaliation case after discussing about credit card sign-up practices with manager. Okay, I'm not sure I understand. I'm not sure I understand the question. So it's not clear to me exactly what we're talking about here, top programmer. So you may want to just rephrase the question and tell me what is the issue. Something about a credit card, but I'm not sure I understand. All right, let's see. Next question is from Bash Borer. Been working as a contractor for 8 years with a local construction company. They've decided to scale back operations and aren't renewing my contract. Does being a contractor mean no severance? Well, here's the thing. You're probably not a contractor in the eyes of the law. Remember, you don't decide if you're a contractor. The company that you work for doesn't decide that. The law makes that determination. So if you look like an employee and act like an employee, you are an employee, and regardless of what you may have signed or think. And if you're an employee, of course, you're owed severance. So you could be owed, after 8 years, significant amount of severance. And by the way, even as a contractor, if you do most of your work for this one company, you're still owed severance. So chances are, very good chance that either you've been misclassified or you're still one of those contractors owed severance. So yes, you are going to be owed severance. What you need to do right now is connect with me, my team and I. Easy to do that, employmentlawyer.ca. By the way, before I continue, for Bash Borer, for any of you, if you believe you're a contractor, but you're not sure, you think you may have been misclassified, you want to know if you're really a contractor or an employee, we have a tool for that as well. You can also go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca, and you click on our independent contractor tool. When you click on it, you're going to answer a few questions, and it's going to tell you if you really are an employee or a contractor. And then you know, again, free and anonymous. So check it out for yourself. But for you, Bash Borer, you need to connect with me as soon as possible so we can get you that severance. And yes, those working in construction are owed severance. Okay, employmentlawyer.ca to connect with me. All right, let's see. Next question from Sheila. If long-term employees can't perform duties due to injury or illness and no possible accommodation based on their skills and physical limitations, exhausted EI, no disability benefits, termination pay owed. So I'm not sure if you're asking a question or if you're saying something, but let me kind of break this down. If you're unable to work, and first of all, your employer has an obligation to accommodate. And just because your employer says, oh, we can't, doesn't mean that they can't. Doesn't mean that they shouldn't be. It's very difficult to say to an employee, oh, we can't accommodate you. It would have to be, the accommodation would have to be so extreme that it's just not possible. In the vast majority of cases, in my experience, when an employer says, oh, we just can't accommodate, they can, they're just choosing not to. Or they just think, it's too hard, so we don't want to do it. That's not right. That's not legal. Okay. So right off the bat, we need to deal with that. Beyond that, if truly they cannot accommodate you, you can be off on a medical leave and you can get EI or short-term disability, or it can be unpaid until your restrictions are changed so that you can go back to work. The fact that you cannot be accommodated doesn't mean that you're terminated. It simply means you can be off work until you get better. Now, if your restrictions are permanent and they'll never be able to accommodate you, you'll never be able to go back to work, then yes, you may be owed severance. Not your full severance, but a part of it. And again, that also depends from province to province. But the best way to deal with that, of course, call me. Let's have a discussion so I can understand exactly about your situation, what you're owed, etc. Employmentlawyer.ca to connect with me. So let's make that happen. Again, employmentlawyer.ca for that. All right. Continuing to answer questions. By the way, if you're just joining us, thank you. I'm Lior Samfiru, the employment lawyer. Still have some time here. You can still get your question in under the wire. So ask your question about employment law. Bronto has our next question. Employer asked me to move to a new work location. This required me to relocate to a different city. They've since changed their minds and said I need to go back to the other locations. If I don't, then it's a resignation. Is this accurate? Absolutely not. If you had to relocate, now they want you to go back, that's a constructive dismissal. Okay, what that means is you can consider that a termination. So if you say no, and as a result of that, you lose your job, that's a termination, and they owe you severance and potentially other damages as well. Because if they represented to you that, hey, if you move, you're going to have long-term employment, and it turns out to be false, There could be additional damages that they have to pay you, but of course they have to pay you severance. It's not a resignation. Okay, so what I want you to do is make your decision. If you decide not to and you lose your job, you call me. Frankly, better before you even make that decision. Before you speak to them, before you tell them anything, let's have that conversation so that we can be on the same page and we can dot our I's and cross our T's. Of course, to connect with me, I've said that. I'll give it to you again, employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic. Great questions. Let's continue. Let's make it happen. Again, I'm Lior Samfiru, the employment lawyer. Bronzor has our next question. What's the difference between the common law and employment standards? Why are they different? So I touched on that earlier. So the employment standards legislation in every province provides for certain minimums. So it outlines minimum wage. It outlines the minimum amount of vacation that you get. And it also outlines the minimum amount of severance or of termination compensation that you're owed if you lose your job. But that's just minimums. And every employee has more entitlements, additional entitlements under common law. Okay, so at the end of the day, for most people, the Employment Standards Act amounts are irrelevant because let's say you make $80,000 a year. Does it matter to you that minimum wage is $15 an hour or whatever it is? It doesn't matter because you're making $80,000 a year, so it's irrelevant. For most people, those minimum entitlements are irrelevant. You're owed potentially 50 times more than that. To find out how much you're actually owed, your full entitlements, your common law entitlements, you call me or you go to pocketemploymentlawyer.ca and use the severance calculator. Okay, so that's how that works. Too many people are confused. They may try to research online and they find out, oh, I get a week per year. They don't realize, no, that's your minimum entitlements. That's not what you're actually owed. You could be owed 3 months per year. So that's the difference. Bronzer, if you lost your job, you need to get your full entitlements. Call me or do it yourself. Use your severance calculator. You'll find that at pocketemploymentlawyer.ca. Fantastic. A couple more questions I think we can get in. Angie. Angie has our next question. How do you make an employer understand common law or severance as to avoid going to court as they feel they owe nothing but the minimum after 6 years in a supervisor role? I want to come to a fair, presumably, resolution. Well, they're not going to take your word for it. So what we need to do is I need to contact them because as soon as I do, guess what they'll do? They'll call their lawyer. Their lawyer is going to say, yeah, you owe that amount, and we resolve it. You're not going to court. The chances of you having to go to court is 0.5%. It's ridiculously small. So that's how that works. So you always think, well, I have to go to court. Of course not. You won't be within 1,000 feet of a courtroom. So Angie, you are owed common law entitlements. Your employer doesn't understand. That happens very often. They're not going to listen to you because they think they know better. As soon as they get a letter from me or my team, they'll call their lawyer. They find out we resolve this. Couple of weeks, you're done. So that's how that works, Angie. So if you lost your job, let's do this right. Connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca, and let's make sure you get everything that you are owed. Too many people are afraid of the legal process. They think, well, if I speak to a lawyer, I have to go to court. Of course not. To me, court is a dirty word, honestly. We go to court if everything has failed. Okay, in the vast majority of cases, not even close. Our job is not to go to court. Our job is to get you what you're owed. It's as simple as that. So again, employmentlawyer.ca. Guys, I think this is the time we have for today. Lots of questions. I love it. I'm so grateful to have this opportunity to talk to you, to get questions answered, to hopefully alleviate the concerns that you have. Now, I'm going to turn off this camera here in just a few seconds, but I'm not going anywhere. My team and I are not going anywhere. Andrew says, after reaching out through a lawyer a few times, they still say they don't understand. Well, call me, okay? We'll resolve this in 2 weeks. Again, employmentlawyer.ca. I'm not going anywhere, as I said. You can reach me today. You can reach me tomorrow. My team and I just go to employmentlawyer.ca. Very easy to do. I'll be back next week to talk to you more right here. Don't wait until then. If you have a question, an issue, a problem, contact us today through employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer with Samfiru to Markin LLP. Thank you again so much for being here with me and asking those questions. Always a privilege. Thank you. We'll talk to you all again very soon. Bye now.